Good morning, Ms. Taylor.
Good morning. May it please the court, excuse me. My name is Susan Taylor and I represent Mr. Muniz. Mr. Muniz was convicted of 2 counts of armed robbery while masked and the remaining 5 single counts of carrying a firearm, possession of a firearm, possession of ammunition, possession of cocaine, and possession of marijuana.
And he objected.
And Mr. Muniz's counsel made a specific Crawford objection to the admissibility of both the ballistics certificate as well as the 3 drug certificates that were admitted into evidence. Given that such an objection was made, and in light of the ruling in Melendez-Diaz, the Commonwealth has conceded that the standard of review is harmless error. And harmless error, the question is whether the evidence had or might have had an effect on the jury and whether the error contributed or might have contributed to the verdicts.
Okay, and to be clear, you have conceded that the armed robbery convictions stand, correct?
Yes, Judge.
Okay, so we're only talking about the firearms and the drug.
Correct.
Can you begin with the ballistics, or did you want to go there?
Absolutely, Judge. Unfortunately, I think that the courts in the appeals courts since Melendez-Diaz have adopted looking at the Commonwealth versus Isabel case, which sort of sets out how harmless error should be evaluated. And in this case, unfortunately, there's a great deal of emphasis on the 3rd factor, which is the weight of the evidence, because in all of these cases, there is no curative instruction because it wasn't a mistake to admit them in the first place. The government always is the one that admitted them, and there may have been a frequency of reference. And for practical purposes, certainly in this case, once the judge has overruled your objection and said, well, they're going in even though you object, at that point, where would you go with it? How would you make it a live issue once the judge has said, you're not entitled to confront the analyst that examined the drugs or the ballistician who had examined the gun? So in this case, unfortunately, if there's so much emphasis on the sufficiency of the evidence, it detracts from the standard. And the standard is not, was there sufficient evidence, putting aside the certificates, to find the defendant guilty of the offense? The issue is whether the certificate had an impact on the jury.
Could I ask you this? With respect to the gun, did the one or both of the victims, I take it the gun was found, I think, in a vent in the apartment on High Street, right?
Yes, that's correct.
At trial, did one or both of the victims identify that gun as the one that they said the defendant, or one of them said the defendant was pointing at her or threatening to shoot?
They didn't make an in-court identification of the weapon. There was not an in-court identification of the weapon. Rather, the police testified, and the witnesses themselves testified, that on the day after they had gone to the police station, they were shown a single photograph of the weapon that was admitted into evidence. And they said that that gun was similar to the one that was used. But it would be speculative, and certainly you can draw the inference that the gun recovered from the vent in the kitchen may have been the gun. That's exactly what it is. It's speculation. And whether it was loaded is speculative as well.
But I thought there were some bullets in it. Were there
It
not?
was a loaded weapon found in the kitchen vent.
But you mean whether the gun that was at the crime scene was loaded? That's
Correct.
yeah.
Correct.
Attorney Taylor, I follow what you're saying about the certificate of analysis. Can you sort of shed some light for me on what kind of evidence it would take in the Commonwealth's case to show that the certificate did not have an impact on the jury? How strong does that case have to be?
Well,
Or is there no case?
Well, Judge, I would suggest that there is no case.
You'd
in
say
which
even the
you can overcome
marijuana
a
in your case?
certificate.
The
Because
marijuana cigarette in your case?
pardon me, Judge, I'm sorry, I didn't hear your
The
question.
marijuana cigarette in your case? You
Oh.
wouldn't think that was
Well,
strong enough?
The question of whether it's marijuana, I suppose you then are confronted with the issue of which marijuana possession are we talking about?
Okay, but just the idea of smell, admission, I mean, those things would go to a strong case, wouldn't it?
Well, I would actually, one of the amicus briefs that was filed with the court references a D.C. case, I think it was United States versus Duval, or Duval versus United States, where that particular court said, anytime you have a certificate, the certificate that goes into the jury room, the fact that the jury can look at it and say, gee, there is a scientific analysis which confirms that this substance is in fact marijuana, the jury's going to forget all about whether somebody smelled it or what it looked like. I would suggest that in almost every case, the certificate would almost always trump whatever sort of testimonial evidence.
Trump or be cumulative. The whole point is if the evidence is overwhelming, is cumulative evidence such that it would affect the jury.
But at the same time, had you
I shoot the gun at you.
In the prior case in Vasquez, you had two certificates where, in fact, drugs were found and one that was not. So I would think that, given that, if a jury feels like it can rely on a certificate, why would it have? If every time we acknowledge our births, our marriages, our deaths, all with certificates, and when you look at the certificate, you believe that the information contained therein is correct.
Well, it depends, but certainly if you have a certificate that says Commonwealth of Massachusetts, bang, there's the stamp, the governor, Department of Public Health, State Laboratory Institute, I hereby certify, so on and so forth. I mean, it's not just any old certificate,
Yes.
right?
And at the
It is
conclusion of the
your
trial,
government.
the judge draws your attention to the certificate and tells you that there is a law that says that you may accept that certificate, as prima facie proof of the facts.
Yeah, but I mean, there's got to be some case that is harmless beyond a reasonable doubt.
Well,
I mean,
the court has determined that in Connolly that was harmless beyond a reasonable doubt. But in that case, there were the drugs themselves were field tested. There was some other, whether it was scientific or not, there was some sort of basis other than the mere observation of looking at it, which is not sufficient. And the question then becomes, in the Commonwealth versus Keller case, I mean, obviously the appeals court believed that the smell of marijuana was sufficient circumstantial evidence. In this case, once again, you're taken back to the question on the marijuana charge. It's really impossible to determine which marijuana possession is the subject of the indictment, because there's 2 packets of marijuana that are found in the apartment and a single marijuana cigarette. It's 2 separate possessions. They were not contemporaneous. One occurred earlier in the afternoon and the other later in the day. But it's impossible to determine from the indictment itself which possession the indictment refers to. But going back to the ballistics, the question of what other evidence was there for the ballistics. In this case, unlike, first of all, Commonwealth versus Fancy was decided back in 1965. And I would suggest that the technology and the production of guns, that a lot of things have changed since 1965. But the court in Cherry basically said that you cannot look at a gun and tell by simply looking at it that it's operable. And the court in Hollister expanded on that and said that although a gun is loaded, because there's an inference since Commonwealth versus Fancy that a loaded gun is operable, that you cannot look at just the mere fact that it is loaded is not sufficient for you to conclude that it is operable. And in this case, other than the fact that Detective Reardon testified that he recovered a loaded gun, a 9mm Beretta. It appeared to be in good condition, and it was loaded. That's the state of the government's evidence on the gun. And in addition to that, unlike some of the other cases, the record indicates that the gun in this case and the bullets, neither of them were sent into the jury room. And the only thing with regard to the gun that would have gone into the jury room would have been the ballistician's certificate, which attested that the gun was operable, that the ammunition and the gun itself were a firearm and evidence within the meaning and as defined by Massachusetts General Laws, Chapter 140, Section 21. And at the conclusion of that certificate, the person who notarized the ballistician's certificate says that he knows this person to be a qualified ballistics expert. So I would suggest that it can't be harmless beyond a reasonable doubt when the certificate that went into the jury room attested on a piece of paper that has at the top a Commonwealth of Massachusetts Department of State Police, at the bottom, excellence in service through quality policing, that it can't be harmless beyond a reasonable doubt
In this case.
in this case. Now, with regard to the cocaine that was seized, I think the government has acknowledged in its brief that other than the certificate, there was no other evidence of what the substance was that was seized in the apartment. And it comes down to really, in terms of the possession of marijuana, certainly there was some circumstantial evidence with regard to whether the marijuana cigarette was marijuana. But with regard to the 2 packets of marijuana, suspected marijuana that was seized in the apartment, that there was no other evidence besides that.
Remind me what the defense was in this case?
I'm sorry, I didn't.
This was an identification defense? This was an ID defense? This was an armed,
Yes,
this was an
yes,
armed
a
robbery?
lack of ID.
Lack of ID.
defense,
It's not-
yes.
wrong guy.
So, but you're saying that that this was a live issue because he objected.
Yes.
That preserves the live issue.
Well, Judge, I would suggest that since the government has to prove what the substance is beyond a reasonable doubt, and they have to prove the operability of the firearm beyond a reasonable doubt, that whether they can sustain their burden is always a live issue.
But we have a lot of cases where there are mistakes in murder instructions. And I don't want to say a lot of cases. We have some cases where there are mistakes in murder instructions, and we say because the fact that somebody was murdered was not a live issue at trial, but identification was the defense. We use a different standard of review.
Well, I think that the court in the prior arguments,
Or we're more forgiving, I should say,
Well-
of the mistake.
in this case, since Melendez-Diaz, and in fact, in all the cases that involve any kind of, where they involve some certificate that was admitted,
But in your case, the defendant objected.
right. And so the standard is harmless error. And I would submit that the admission of those certificates was not harmless beyond a reasonable doubt. But I would submit that whether defense counsel had objected or not, whether or not the government has met its burden for each and every element of the offense is always a live issue. And unfortunately, for those people who did not object, how does whether the government can satisfy its burden ever not a live issue?
Well, but the government can satisfy its burden in lots of different ways. So it's a live issue in the sense that the government has to establish all the elements of the crime.
Right.
But it may not be a live issue in the sense that it's not even contested in the case that these were drugs, and the only issue contested was whether or not he possessed them or somebody else possessed them. I mean, that also is a reality of a real trial. Still got to prove they're drugs in some fashion.
But if the Supreme Judicial Court in your jurisdiction, which has a reputation for always according greater constitutional rights and basically providing greater protection than others, has said that it's not admissible, that these are business records and they're admissible and not subject to confrontation, how do you waive the fact that it's not a live issue, that you had the right to confront and cross-examine the examiner that examined the drugs or the weapon?
Well, of course, you can get your own expert.
But the Melendez-Diaz drew the distinction between compulsory process and...
I'm just saying, you're saying, well, how can you possibly challenge the analysis? Of course you can challenge it.
But the United States Supreme Court
That's
has
why
said
it's error, but that doesn't answer the question as whether it's harmless, but in any event. I understand your point.
Thank you.
Thank you, Ms. Taylor. Ms. Dillon?
Good morning, Your Honors. May it please the Court, would you like me to start with the ballistics certificate? Since we've gone past
You may use the time anytime you would like. You may
Thank you.
use the time to argue any point you would like.
Thank you, Your Honor. The robbery conviction is out of the contention here, which is good news as far as the Commonwealth is concerned. As far as the ballistic certificate on the gun is concerned, the handgun that was found in the defendant's apartment very shortly after the robbery not only had rounds in the magazine, it also had a round in the chamber. And the fact that a round was able to be put into the chamber says something about the working mechanism of that weapon.
Was there somebody who testified to that
Yes.
fact?
Yes. Oh, that it says something about it?
Correct.
No, there was no testimony about that. There was just testimony that that was the condition of the handgun.
So if you're a if you're like me and know nada about guns, how would I know that makes any difference as to whether it's operable?
Well, at least since 1965, this court and the appeals court have said that you do not need expert testimony, that weapons are just not, and then in this case, it was not.
I'm not talking about sufficiency. I'm just talking about whether that is going to trump the fact that you've got the certificate of that it's a working firearm in evidence.
The circumstantial evidence that the Commonwealth presented, the competent circumstantial evidence that this weapon was in fact an operable weapon, was that there was a weapon that was found in the defendant's apartment, that there were rounds in the magazine, and that one of the rounds ended up in the chamber. I don't think that this is anything that's beyond the ken of many jurors. In addition to the fact there was testimony from the witnesses who did identify that weapon as the one that was used in the robbery, that the defendant said to them, do what I want, do it quietly, or I will shoot you.
Did they say it was similar to, or did they say that the photograph was it?
They said it was similar to, but it's not unusual for victims of crimes to identify a gun in particular or a knife as being similar to the one that was used at the crime. But when you add that to the fact that it was found in the stove vent in the defendant's apartment.
In the stove?
Stove vent, yes.
Yeah. Oh,
In
okay.
his kitchen. Very shortly thereafterward, there's more circumstantial evidence that this was in fact the weapon that was used in the robbery.
The mere fact that it was used in the robbery wouldn't say that necessarily it was an operable firearm. We have all the time persons who use non-operable firearms or things which look like firearms to do robberies.
That's true. But in addition to that, while the defendant was in the process of intimidating these two women to get the money from them, he said, you do what I want and you do it quietly, or I will shoot you. That's another piece of circumstantial evidence. We're just adding to the weight of the circumstantial evidence.
I guess the question goes to Justice Botsford's, which is we're not dealing here with sufficiency. We're dealing with the issue of whether we're confident beyond a reasonable doubt that without this evidence, the jury would have found it to be an operable firearm.
Yes, but I don't think that we can say that any time a certificate has been admitted in evidence, all of the Commonwealth circumstantial evidence, as competent as may be, goes out the window just because there's a certificate. If you look at the Mahdi case, and you look at the Diaz case, and you look at the Rodriguez case, it says that the theory of the case and the defense and the weight of the evidence is something that does come into play when you are weighing whether or not the error of admitting the certificate is harmless beyond a reasonable doubt. If you take at least the jurisprudence from 1965, saying that you do not need an expert to say that a gun is an operable weapon, that the Commonwealth's burden is not heavy, is exactly what it says in some of them. I would submit to you, Your Honor, that the evidence in this case, as far as the handgun that was loaded with the chamber, 1 round in the chamber, is sufficient for reasonable jurors to go in there and determine that the Commonwealth has proved beyond a reasonable doubt, not beyond all doubt, but beyond a reasonable doubt, if you use a Hubert standard, that you can be satisfied that this did not sway that jury.
No, that's not, it's that, I'm quoting from Chapman. The question is whether there's a reasonable possibility that the evidence complained of might have contributed to the conviction.
A reasonable possibility, that's true.
That the evidence complained of, that is the certificate,
certificate.
might have contributed to the conviction.
But if the quantum of the rest of the evidence, when viewed in its entirety, weighs heavily so that a reasonable juror could find beyond a reasonable doubt that that was an operable gun, the fact that there was also a certificate should not just void the rest of the evidence. That's not how the other cases have defined your job in weighing whether or not the error was harmless.
But of course, we don't, this is not a case in which the individual fired the gun at the bank
No.
into the ceiling, and they could show that it was observed to be fired and that the
Right.
ballistics match. We don't have that.
We don't have that, and if we had that, we would have had the ballistician and we wouldn't have this issue because of that. But even if you had, I heard shots, I smelled gun smoke, and we went in there and there was a round on the gun on the floor, you know, that would be stronger. But we don't all get the strongest of cases. We work with the evidence we have. Sometimes the evidence is not the ideal evidence, but is still competent, and it's enough to convince reasonable jurors and reasonable justices that, in fact, that gun was operable. And we know that the ammunition was designed to fit in that weapon because it did fit in that weapon. And at least one of those rounds got from the magazine into the chamber. And that's how they work. I mean, it's so easy. It's just like a Pez dispenser. You push the button and the next one goes up. This is not rocket science.
The officer testified that it was a 9mm Beretta.
Yes.
All right. Is there any significance to that?
No.
Okay. So that doesn't tell us anything of importance as to whether the gun is operable? Just,
No, that just identifies it.
okay. I mean, there could be, I guess, fake 9mm or inoperable 9mm Berettas, I suppose. The officer said it was in good condition. Does that add any weight to this at all, or really not?
I think that it does add some weight, not tremendous weight. but
Wasn't
it
broken, didn't
wasn't-
appear to be broken. Or,
wasn't rusted out. It appeared to be in good condition. It was loaded, and one round had made its way into the chamber, and I think that is a significant fact. Not only
Did
as
the
to,
officer explain how rounds move in a gun?
no.
Ms. Dillon, could you help me on a separate point, which actually doesn't necessarily arise here, but I would be interested in your views. We were having discussions earlier about a new rule or not new rule, and I'm just trying to find here Crawford, the language in Crawford, which doesn't exactly say that Melendez-Diaz is not a new rule. I mean, it's got some, it says, at least this much is entirely clear. In faithfully applying Crawford to the facts, we are not overruling 90 years of settled jurisprudence. It is the dissent that seeks to overturn precedent by resurrecting Roberts, on that. Is that the court saying this is not a new rule?
I think that when Justice Scalia said that this is a straightforward application of Crawford, he was saying this is not a new rule. I can think of no other interpretation for that line.
Okay. If If you have no further argument, thank you.
Thank you, Your Honor.